Welcome back to State and Local Government and Politics, Module 5, State Constitutions. In Part 4, we'll discuss the role of the courts. The state courts have a major role in amending state constitutions via their exercise of the power of judicial review. Unlike the U.S. Supreme Court, which under most circumstances won't address political questions, legally classified as non-justiciable issues, state appellate courts often rule on a wide range of both procedural and political issues. In the past, state courts of last resort have ruled on issues such as whether a state can call a constitutional convention, the validity of procedural mechanisms used in carrying out eminent domain powers, and whether some amendments developed by legislative and popular initiative are consistent with constitutional principles. Because state appellate court judges are elected in most states, unlike their lifetime appointment judicial counterparts in the federal courts, state court judges generally have a stronger sense of connection to the people than do members of the federal judiciary. Opponents of constitutional amendments enacted through the initiative process frequently have used the state courts to question the legality of such amendments in order to prevent them from being placed into effect. For example, opponents of Oregon's ballot initiative 36, which amended Oregon's constitution to say that only a marriage between one man and one woman shall be valid or legally recognized as a marriage, unsuccessfully used the state courts to challenge the initiative, arguing in their brief that this statement represented such a radical change to the Constitution that only the legislature or constitutional convention should have the ability to make such changes in the foundational framework of Oregon's legal system. The role of the state courts, known as the exercise of judicial federalism, is a recent phenomenon emerging in the 1970s when Warren Burger succeeded William Brennan as Chief Justice of the U.S. Supreme Court. As the U.S. Supreme Court lost its liberal majority with the appointment of Burger and began to take far less progressive stance on civil liberties and social equity cases, the high courts in states began interpreting their own constitutions to establish citizens' rights in their states beyond those present in the U.S. Constitution. Judicial federalism refers to the allocation of power between federal courts and state courts, where the state courts address their own state's constitutional claims first in a case and only consider federal constitutional claims when the cases cannot be resolved on state grounds. This increased the influence of state constitutions within their judicial system, particularly in regard to civil rights. This activism on the part of state Supreme Courts adds an important dimension to the adaptive capacity of state government in this area of the promotion of an essential element of sustainability, namely the promotion of social equity. Having established this capacity for court-initiated adaptation to change, this same capacity for adaptive action could be demonstrated in the areas of citizens' positive rights relating to the governmental actions taken to address global climate change or energy shortages or access to information technology. The social equity dimensions of those policies would have to pass muster with state courts, even if Congress remained silent on these matters. In Part 5, we'll discuss constitutional amendment trends and state constitutions and sustainability.